NewsX has accessed the report of Justice Yashwant Varma. As per the report, Justice Varma was evasive during the questioning and his explanations were unsatisfactory. The committee found that the explanation furnished by the judge was evasive, incomplete and misleading in effect. Let's quickly go across to the report at large and what exactly does it state. We have been able to access that document, and let's quickly go to the touchpad so we can move towards it. Well, what it essentially states is the follows. The committee is conscious that the judge was not required to prove his innocence in the abstract. However, where positive factual pleas were raised by him, namely conspiracy, planting, staff involvement, foul play, fake currency notes or removal by public officials, the committee could not be expected to accept such pleas without material. The presenting side had led its evidence, 9 witnesses had been examined, documents and electronic materials had been marked, cross-examination had been fully availed of, and the matter had thereafter reached the stage of defense evidence. Yet no list of defense witness or affidavits in lieu of examination in chief were held, in fact, or filed. The withdrawal of the proceeding is not treated by the committee as a proof of Article 3. Its significance is narrower but real. The withdrawal occurred at a stage when the judge could have rather placed his positive factual explanation on record. Having raised suspicion, referred to inquiries, challenged the role of staff and first responders and suggested alternative theories, he did not lead evidence to substantiate them. The result is that the established facts remained unanswered by the very persons from whose side an explanation could have come. The committee thereafter finds that the explanation furnished by the judge was evasive, incomplete and misleading in effect. It was evasive because it did not engage with the central circumstances of substantial currency notes seen by independent officials inside the storeroom. It was incomplete because it did not disclose the factual steps allegedly taken by him, the details of inquiries made, the answers received from the staff or household members, or any action taken to preserve the site or complain of foul play. It was misleading in effect because the earliest broad denial gave way to successive alternative hypotheses, in fact, none of which was substantiated when opportunity to lead defense evidence was available. Therefore, Article 3 was accordingly proved. And that's of course the information that we are tracking as far as this report is concerned. The reasons why it's been called evasive and incomplete have of course been given in this report itself. Manohar Kesri continues to be with us on the broadcast. Manohar, जानकारी दीजिए हमको, जहाँ तक एक स्टेटमेंट की बात है उसको इनकम्प्लीट बोला गया है, उसको evasive बोला गया है और इस डॉक्यूमेंट में वो रीजंस भी दिए गए हैं. हमारे पास और क्या जानकारी है?
देखिए, बिल्कुल, अगर हम इस रिपोर्ट की बात करें जो अरविंद कुमार जज की रिपोर्ट है जो आज लोकसभा के सदन पर पेश की गई, उसमें 3 जो मेन आरोप थे वो पूरी तरह से सिद्ध हो चुका है, साबित हो चुका है. हालांकि जो दूसरा आरोप है जिसमें नोटों को हटाने की बात हुई है वो जज ने माना है कि उन्होंने खुद से नहीं हटाया है. लेकिन अब सवाल ये उठता है क्योंकि अभी तक तो उन्होंने जो इस्तीफा राष्ट्रपति के पास भेजा था वो अभी तक इस्तीफा स्वीकार नहीं हुआ है. हालांकि उन्होंने 9 अप्रैल 2026 को ही राष्ट्रपति के पास अपना इस्तीफा भेज दिया था और अभी भी इलाहाबाद कोर्ट की सूची में, हाईकोर्ट की सूची में उनका नाम है. तो ऐसे में आगे क्योंकि सदन में इसलिए रिपोर्ट रखी गई थी, विपक्ष की ओर से महाभियोग इम्पीचमेंट लाने की अपील की गई थी. सभी सांसदों ने, जो 140 से ज्यादा सांसद हैं, उन्होंने हस्ताक्षर करके ये मांग की थी. तो ऐसे में अब देखना होगा कि आगे की जो कार्रवाई है वो की जा सकती है.
Manohar, आपका बहुत बहुत शुक्रिया हमारे साथ जुड़ने के लिए. My colleague Sambhav Sharma now joins us on the broadcast. Sambhav, the report is out. We've been able to access the 126-page Yashwant Varma report which essentially talks about how the explanation was incomplete, it was misleading, it was evasive by nature. What information do you have?
Committee, and with this volume 1 with a quorum, I'm just reading Justice Arvind Kumar, Judge Supreme Court, who is the presiding officer; Justice Sri Chandrasekhar, Chief Justice of the Bombay High Court; and B.V. Acharya, Senior Advocate of the Karnataka High Court, a member of this quorum. Report has been submitted. We have the copy of the report, and as you rightly pointed out, there are a lot of details when it comes to this particular report coming out in public domain. And because the report was prepared by 3-member inquiry committee under Judges Inquiry Act of 1968, headed by Supreme Court Judge Arvind Kumar, an inquiry. Obviously, there is a background to it, it's in public domain that after a fire broke out at the night of March 15, 2025 at Justice Yashwant Varma's official residence in New Delhi, and the officials took photographs and videos. Now, this is what the part of the report is. Officials took videos, photographs of the currency at spot, is what the report is talking about, and the material later came into public domain through media reports. Following this, a motion seeking Justice Yashwant Varma's removal was initiated in the Parliament and admitted by Lok Sabha Speaker. And the inquiry committee examined whether unexplained Indian currency was
Sambhav, hold that thought, because we're being joined by Advocate K.C. Kaushik, former Additional Solicitor General of India and former Honorary Secretary, Supreme Court Bar Association. So appreciate you taking out time and speaking to us on NewsX, and the report that has been pushed out. Of course, 126 pages of pure evidence. What exactly were the observations? Okay, all right. I'm being told that that phone line has been cut so far, but Sambhav continues to be with us on the broadcast. Sambhav, why don't you go ahead, please?
Absolutely. This is our report. We have the copy of it, and the inquiry committee, as we were discussing about the inquiry committee, it examined whether unexplained currency was discovered and possessed within Justice Yashwant Varma's official premises. So this is what it examined, the inquiry committee. And the committee also investigated the allegations that material evidence was not preserved and that there was interference with the evidence or not. And another very major issue examined was whether Justice Varma gave evasive or misleading explanation regarding the presence of the currency. And the report conceived, if we talk about this particular report, the report records the committee's findings and set out its conclusion based on evidence. It will take some time to go through this report because it's just out. And
you're absolutely right, Sambhav. We're of course trying to digest it in bits and pieces, and on that front, we have some more breaking information coming our way. As per the report, there was failure to preserve evidence prior to lawful sealing causing interference. Let's quickly put out that information on our screens, and the 126-page report that has been pushed out. What exactly does it say? As far as the findings on Article 2 is concerned, there was failure to preserve, in fact, and causing interference with material evidence, and here is what we understand. Article 2 alleges that subsequent to extinguishment of the fire and before lawful inspection and sealing by competent authorities, material objects and surroundings at the scene were altered or removed while the premises were under the control of the judge, and that the failure to ensure that material evidence was secured or preserved, and in fact in its disturbance or removal amounted to dereliction of institutional duty and obstruction of due process. That's a very important detail that we're tracking. This charge has to be approached with care. it contains more than one element. It refers to alterations or removal of material objects and surroundings, failure to secure or preserve material evidence, and in fact, it also talks about the disturbances or removal and dereliction of institutional duty. It is not necessary for the purpose of this charge to prove that the judge personally carried away any material object. The charge is widely enough to include failure to preserve and acquiescence in disturbance or removal of material evidence within premises under his institutional charge. That's again a very important aspect of this report that has been pushed out with which essentially gets into how there was a failure to preserve the material evidence and how there was interference perhaps that was observed as well. Sambhav continues to be with us on the broadcast. But before we go to Sambhav, Advocate K.C. Kaushik, former Additional Solicitor General of India and former Honorary Secretary Supreme Court Bar Association, is joining us as well. Appreciate you, sir, taking out time and your perspectives on this report that has been published and the findings that have been put in place. I think we've lost that connection over there. We will get that connection sorted momentarily. Sambhav, in the interim, continues to be with us. Sambhav, give us the details, please. How it's, of course, talking about the material evidence, how there was a failure to preserve it. There was interference that has also been written about over here. What more information do we have on that front?
Well, absolutely. This particular report consisting of very important points, and we are still reading it. And for our viewers, I would like to point out few important points here. And the report suggests photographs and the videos of the currency recovered from the premises were taken at the spot and subsequently became public. The inquiry examined whether all these screenshots and relevant things were, the fairness of it. The committee considered various explanations and claims, including allegations that currency may have been planted, or the first responder had removed the material from the spot. And also witness statements, photographs, videos, and other materials were examined by the committee while assessing the allegations. So a detailed report has been submitted here, and I'm just trying to get some more important points here out of the report. And on page number 121, there is something important here. And I'm just reading it out for our viewers. The role of the advocates who have appeared on behalf of both sides require acknowledgement. So if this is what the report is acknowledged. The committee records the final findings and that the articles of charge under clause 1, 2, 3 are proved. The point number 298 of the report and 299, the committee accordingly submits this report together with the record of the proceedings, documents, exhibits, material forming part of the inquiry for such further action as may be considered appropriate by the law. So I would also request producers that page number 120 here is important. Article 3 is proved, is what the report is suggesting, to point number 297. The explanation furnished by the judge, particularly the reply dated 22nd March 2025 and subsequent stand taken, did not exhibit the transparency and subsequent and institutional responsibility. Now, this is a very important point. 297 point on page number 120 of this report says that Article 3 is proved. That I'm reading it for the benefit of our viewers. The explanation furnished by the judge, particularly the reply on 22nd of March, the subsequent stand taken, did not exhibit the transparency and institutional responsibility expected in the circumstances, and it remained evasive. This is what the report is suggesting, that it remained evasive and unsatisfactory when tested against the evidence of independent official witnesses and corroborative material. The committee therefore records its final findings that articles of charges in clause 1, 2, and 3 are proved. Point number 298 on page number 121. So this is what is the crux of it. The consolidated findings on the article of charge, point number 13, 294 on page number 120. In view of the foregoing discussion, the committee records its finding as follows. Article 1 is proved. Point number 295 says that substantial unexplained 500 rupees denomination currency notes were found in the storeroom situated within the official residence premises at 30 Tughlaq Crescent, New Delhi. The judge failed to furnish a satisfactory explanation regarding the presence.
Absolutely. Sambhav, like I said, we want to essentially put this out in bits and pieces so it's better for everyone else to understand as well. We in fact have some more breaking news coming in. The Delhi High Court Bar Association is demanding impeachment of Justice Yashwant Varma. Let's quickly put out some information on our screens that we're tracking on page number 108 of this 126 page report that has been published, and it says that no such satisfactory explanation has been furnished. The defense of conspiracy or planting remains unsubstantiated. No person has been identified. No occasion of entry has been established. No material has been produced to show how any substantial currency notes could have been brought into the premises without detection. No credible alternative source or owner has been disclosed. The plea remains at the level of possibility. The committee is not recording a finding of direct personal ownership of the currency notes in the criminal sense, nor is it necessary to do so for the purpose of Article 1. What stands established is the substantial unexplained currency notes that were found within the official premises occupied by the judge, that the storeroom formed part of those premises, and that the judge failed to furnish a satisfactory explanation regarding its presence, source or ownership. That's again a very important part of this report that is coming to the forefront. Let's quickly put out some more breaking information on that front. The report of the three-member inquiry committee that probed allegations against Justice Yashwant Varma suggested that there was no sign of conspiracy. As per the report, the defense of conspiracy or planting remains unsubstantiated. No occasion of entry has been established as well, and that's exactly what I was getting to, in the excerpts that I was reading from this 126-page report. Mr. Adish Agarwal, senior advocate, joins us on the broadcast to share his perspective. So appreciate you taking out time, and I quickly want to get in your perspectives on this report that has been published. It's of course essentially talking about the fact that there were certain statements that were made that seemed misleading as far as the probe is concerned, and here of course talking about the fact that there was no satisfactory explanation that was furnished, which talks about how the money came in, how the money went out. What do you make of it?
You see, this three-member committee headed by one honorable judge of Supreme Court has submitted its report, and the concerned judge against whom the inquiry was conducted, they found that he could not give the satisfactory reply about the possession of the amount recovered, not recovered, but which was burnt at his residence. So now the Parliament will be discussing the report, and then Parliament will be taking a decision whether this is a fit case for initiating the impeachment proceeding. Hello.
Right, so absolutely, we can hear you, but I do want to understand from you. Uh, the report has come out, many important clarifications have also been given, observations that have been penned. Uh, what exactly do you think is going to happen next as far as this case is concerned, and what perhaps action will be suitable in this case?
I feel that the Parliament will ultimately, certainly, initiate the contempt proceeding after receipt of this report. Although this is very lengthy report, it will take time, and I don't think that during this session any decision will be finally taken by Indian Parliament.
Right, absolutely, sir. With that, I'd like to thank you for joining us on the broadcast, sharing your perspectives with us on NewsX. Like I said, we're trying to decode this report in bits and pieces. We will be putting out further information as well. Again, like I said, that information coming our way. It's a 126-page document that has been published. We're trying to decode it for you in bits and pieces. And here's another important information that's of pertinence that has been put out. Well, based on the information that is given on page number 105, the judge in his statement of defense denied that the compound or storeroom was under his occupation control charge, knowledge or accountability. He asserted that the compound had distinct areas, that only the family quarters were under his occupation and control, that the storeroom was located on the compound but was not under his possession or control, and that he did not lock it before his departure, and that he was unaware of any cash being placed there. 255 point number 255 states, and I quote, the said defense also requires to be tested against the judge's own statement that a liquor cabinet was kept in the storeroom, and that he said that the liquor cabinet used to remain locked. This circumstance is not noticed for the nature of the article stored, but for what it indicates about the character of the room and the judge's own use of it. A locked cabinet containing personal articles is not ordinarily maintained in a space which is wholly unregulated, outside the knowledge of the occupant or beyond his effective control. The presence of such a cabinet and the judge's own assertion that it was kept locked materially weakens the plea of the storeroom, which was merely an open, freely accessible and uncontrolled space near the staff quarters. With that, of course, we do in fact move on to some more breaking updates that we're tracking on the broadcast. The Air India captain of the Phuket to Delhi flight has appeared before the